Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. All of our fees are based on a sliding scale, which are based on your income. So the less you make, the less you have to pay. Today, we're going to be discussing privileges in Massachusetts. A privilege. What is a privilege? Well, a privilege is a concept in evidentiary law. What it is that a privilege arises when somebody does not want to testify. If somebody holds a privilege, they can refuse to testify in a court proceeding. So what happens is oftentimes privileges come up because of a connection one person has with another. A common privilege is a lawyer-client privilege, a confidential communication between a client to the lawyer. The lawyer cannot testify, cannot repeat what that information was, because that's protected under the law. A doctor-patient have a privilege as well, as does a religious person, such as a priest and a parishioner, especially in a confessional situation. Two of the most common privileges that we see in the district courts in criminal matters in Massachusetts are the Fifth Amendment privilege and a spousal privilege. A Fifth Amendment privilege doesn't have to do with your relationship with somebody else. A Fifth Amendment privilege means that you cannot be forced to testify if your testimony would tend to incriminate you or expose you to any criminal liability. And what that means is that if your testimony is going to subject you to anything that could be charged as a crime, the Commonwealth cannot force you to testify. We see this most commonly in cases of assault and battery. What happens is oftentimes the alleged victim will have a Fifth Amendment privilege, and it arises out of a situation where, say, there's a fight between two people. So you're charged with assault and battery, and there's an alleged victim in the case as well. The two of you are fighting back and forth. If the victim was called and testified that he or she assaulted you or beat you, and a battery is basically any offensive touching. So if they slapped you, struck you, punched you, pushed you, anything like that, that could be a crime, and that could expose them to criminal liability. If their testimony was going to be that, then they could not be forced to testify against them. They have a Fifth Amendment privilege against self-incrimination. We all have that right through the Fifth Amendment of the U.S. Constitution. So that's the most common, I would say that's the most common scenario where privileges come up in a criminal case in Massachusetts. Number two, most common would be a spousal privilege. And that does have is based on a connection between two people. So if you are legally married to somebody, your spouse cannot be forced to testify against you in a criminal case if they choose not to. Okay, so what happens is a spouse cannot be forced to testify that you struck them or engaged in some sort of criminal activity. It doesn't come up because they're exposed to criminal liability. It comes up because from the idea that the law does not want to impede on the marital bond. So they don't want to interfere with that bond. So the person can refuse to testify if they choose to do so. In both cases, whether or not a privilege exists, a person can testify if they choose to do so. So in the Fifth Amendment situation, even though a person would have a Fifth Amendment privilege not to testify, they may choose to waive that privilege and testify anyway. So oftentimes what happens is if the person is angry at you or is in fear of you or something like that, and they want to take the risk that they would face a criminal charge themselves, they may waive their Fifth Amendment privilege and testify against you anyway. So that's kind of the long and short of privileges. And what happens is in these cases, especially, well, in either case, oftentimes the alleged victim is the only person that the Commonwealth has as a witness. So their testimony would be the only evidence that they would have against you. If they choose not to testify, then the case goes away. we would move for a dismissal, and more likely than not, the Commonwealth could not proceed. Now, sometimes they have a third-party witness or surveillance or something like that, but if they don't have anything else, without that witness's testimony, we can oftentimes get the case dismissed because of that. It's called dismissal without prejudice for failure to prosecute. So that's privilege. As I say, at Ford Law, we do practice criminal and family law throughout Massachusetts, and our fees are on a sliding scale. That means the less you make, the less you pay. We are trying to give voice to the hardworking men and women of Massachusetts in the courtroom, because for too long they have been left out and been unprotected. Please visit us at affordlaw.org. Feel free to book a free virtual appointment. I'd be happy to answer any specific questions you have about your case, about your situation, or any other matters that you might have a question. At Afford Law, we're making justice affordable. Thank you.